Good afternoon, ladies and gentlemen. Thank you for joining us for this session. Please allow us, or rather, please give us 5 minutes to allow other participants to join us, whereafter we'll start with the presentation. How do you? Welcome all again to the Oraron Company Advocates Fresh Thinking webinar on data protection. With me is Mr. John Baluto, a partner in our disputes resolution department. We also have Daniel Ouma, who is a partner in the disputes resolution department too. We also have Jacob, who is a partner in the corporate and commercial department. Well, all companies have data such as personal files, customer data, product information, and financial transactions. Decisions that management make is based on this data. It is for this reason alone that data protection is very important. That is why the government saw it fit to enact the Data Protection Act. So as a firm, we thought that it's important to enlighten our clients on the salient provisions of the Data Protection Act. Thus, this webinar. We are aware of companies in Europe that have been subjected to hefty fines because of data breaches. For instance, the British Airways company was subjected to a $26 million fine because of data violations that took place in its systems. The regulator indicated that violation could have been avoided had British Airways put in place security, or rather data privacy measures to enhance security of the data. So Kenya has joined the bandwagon and has enacted the Data Protection Act. And we therefore are here to bring to your attention the salient provisions of the Act today. And on the 27th, we will highlight the provisions of the regulations, the 3 regulations that have been drafted, rather published by the Office of the Data Protection Commissioner. A few housekeeping rules. If you have any questions, please indicate them on the question tab on your screens. Please note that the webinar is being recorded. And if your connection drops for any reason, please feel free to click on the link that was sent to you and join the seminar. Without further ado, please allow me to welcome Mr. John Baluto, who will take us through the salient provisions of the Data Protection Act, and followed by Daniel Ouma, who will take us through the provisions on consent. Over to you, John.
Thank you for that, Millie. So perhaps we could just move down the slides to where we should be, which is the outline of the presentation, which Millie has already taken us through. We shall have first a background of the Act together with salient provisions. We shall thereafter go through some of the arising jurisprudence, time allowing, and hopefully we shall have a session that allows for Q&A, perhaps around 30 or so minutes at the tail end of the presentation. In the meantime, as Millie has indicated, if you have any questions, don't wait until the very end. You can post them on the chat, and we shall be happy to take those questions as we go along. So a good point to start with any law in Kenya is the Constitution of Kenya, which is known as the bedrock of all laws, from which all other laws flow. So with regard to data protection, that is found in Article 31, in particular 31C and D, which provides that every person has a right to privacy, which in this case means the right not to have information relating either to their family or their private affairs unnecessarily required or revealed. And secondly, that the privacy of their communications is not infringed upon. So that is what Article 31CD provides as a constitutional right under the Bill of Rights. And for the period between 2010 and 2019, before the coming into force of the Data Protection Act, courts have actually upheld the principle of data protection and privacy, perhaps most famously in the case of the Huduma number case, which was filed by the Forum of Nubian Rights against the AG, in which case the court struck down as unnecessarily intrusive the attempt by government to collect DNA on people as well as GPA coordinates. The court really said, look, that is one thing to say you want to come up with a system as was envisaged, but going to the extent of asking people to have their DNA taken as well as GPA coordinates was found to be a step too far. So by and large, there have been instances where prior to the enactment of this act, courts have been giving or breathing life and enforcing Article 31, C, and D. But at the same time, when our courts were doing what they could in as far as Article 31 is concerned, there was a global movement by various nations, perhaps with a focal point in the European Union, where they were coming up with their own legislations regarding the issue of data protection, which was no doubt brought about or necessitated by the advent of the digital age, where we find data processing being quite pervasive. It's an everyday life encounter. And therefore, for that reason, very many countries at the same time are moving to legislate different pieces of legislation, with a major advancement, as I indicated, coming out from the European Union, who promulgated their EU General Data Protection Regulations, short form EU GDPR, which came to force in May of 2018. Now, this EU GDPR, actually, if you'll allow me to, I'd refer to it as the biblical mecca or the true north of all data protection legislation, because it actually provides more or less a template from which many other nations have borrowed, not least Kenya. And even if you do look through the EU GDPR, you will notice that a lot of the salient provisions that arise from the EU GDPR actually find their way into national legislation by way of mirror image. Next slide, please. So just to highlight some of those salient provisions in the EU GDPR, the first thing you'll find that its territorial scope is quite wide. It applies not only to EU citizens, but is actually applicable outside of the EU, provided that the data subject is an EU citizen. It also applies where companies are either selling services or goods to persons within the EU. So it's a legislation or regulation of quite wide applicability. And therefore, even as we go about our businesses here in Kenya, we should be minded to be aware of circumstances whereby those regulations actually apply to us. Reason being not least that the fines prescribed are pretty hefty, set at a threshold maximum of 4% of the annual global turnover, or up to 20 million euros. Now, if you convert 20 million euros at the current exchange rate, you're looking at an amount of around 2.5 billion Kenya shillings, which is a tidy amount of money by any standards. Another salient provision is that data breaches must be reported to the regulator as promptly as possible, and in any event within at least 72 hours of one becoming aware of such breach. If you're relying on consent under the EU GDPR, you must be able to prove that that consent was properly given in terms of what is required for a valid consent. My friend Dan will speak more about consent when his time comes around. Again, there is a provision set out under the EU GDPR that stipulates when you should undertake something called data protection impact assessment. You'll find out it has also been incorporated into our act. Also contains various data subject rights, which we shall also go into in more detail, and the concept of privacy by design and default. The idea here, as will be alluded to by my colleague Jacob when he gets time, is that you should always have privacy in mind when setting up your system from the outset, so that you inbuild this from the get-go and not try to comply retroactively. So that's what is meant by privacy by design. Next slide, please. So moving on, closer home to Kenya, where we find the Kenyan Data Protection Act. It was assented to by our president on the 8th of November 2019 and came into force around a fortnight later, which was on the 25th of November. And from that date, it became applicable. So notwithstanding that there are still regulations to come into force, the Act itself, be very mindful, is in force, and its provisions are binding to all as we speak here now. As indicated earlier, it gives force or gives effect to Article 31 C and D of the Constitution, and also provides for rights for the data subject, as well as obligations for data processors and data controllers, who we shall come to see who those are as we go about the definitions. It also provides for the Office of the Data Protection Commissioner, or DPC, and the Data Commissioner, who was actually appointed on the 12th of November. Her name is Immaculate Kasait, who together with her has now appointed staff to assist her in the carrying out of her obligations under the Act. I will now address a few major or salient provisions of the Act, starting off with key definitions. What is data? Now, data essentially is information which is processed by automatic means. That's one definition. So any information that you're processing automatically is data. It is also information that is recorded in a filing system. So if you have any filing system that you've come up with, whatever is in that filing system is data, right? Also, data that is stored or retained by a public entity qualifies as data. So remember that data is anything that is automatically processed, forms part of a record, forms part of a filing system, or is retained by a public entity. What then is personal data as distinct from data? Personal data is any information which, when pieced together, can identify an individual, right? So if you have somebody's ID number, that in itself is personal data, because that can identify the person at the tail end of that ID number. If you have someone's name, that also is very identifiable. If you have someone's age or postal address, if you put that together, you can still come and identify a person. So personal data is any data which relates to an identified or identifiable person by piecing together these pieces of information. Processing is a whole host of activities related to that data: collection, storage, retrieval, destruction, disclosure. So any process that you apply to that data is what is referred to as data processing. I'll give a few examples of this in everyday life. So for instance, processing of employees' payroll is data processing. Analyzing customers to understand a bit more about them is also an example of data processing. Sending messages to clients or even advertising to them is data processing. Taking details or information for people who visit your offices. You know how people usually say, put your name, number, ID card. That is you're processing data when you do that. Destroying or archiving old material is also a day-to-day example of data processing. A data subject is anybody to whom data relates or refers or applies. That is who a data subject is. A data controller is a person who decides from a decision-making point or strategic point of view when the data is going to be processed, and the how and the when. So the decision-making person behind the data processing is a data controller. The data processor is the individual who actually does the processing. It can either, more often than not, you find that it's actually the same person, depending on how huge an organization is or on its structure. But other times you find that there's a distinction between who the data processor is and who the data controller is. It is therefore always important to understand exactly who you are or where you fall within this trinity of data subject, data controller, and data processor, because depending on who you are, you either have rights or obligations. So please take time to reflect and understand who it is you are. Now, under the Act, Section 6 stipulates its objects and purpose, which is to obviously regulate the processing of data, to ensure that the rights of data subjects are safeguarded, and also to set up mechanisms towards this protection of personal data. It also obviously pursuant to the subject data protection rights is to provide for remedies and relief of those rights. Otherwise, it ends up being a right without any remedy. And the right is only sweet once you realize what it is if it's breached. We shall come to the penalties at the appropriate stage, but similar to the EU GDPR, Kenya has not shied away from coming up with a stiff regime in the event of data breach. Section 5 establishes the office of the OPDC that I indicated, and we have Madam Kasaitu already in place and doing a good job in terms of engaging the stakeholders so far, and also coming up with draft regulations, which are imminent in terms of their rollout. And the functions of the office are set out in the Act, essentially to bring force into this Act. Due to time constraints, I will not go into the detail, but the ODPC is really the entity that is set up to ensure strict adherence to the Act. Section 18 of the Act places an obligation on data processors and data. Let's move on a few slides. Data processors and data controllers to be registered. How do they do this? They actually place a bar. They say, do not process data unless you are registered. But then subsection 2 then says that the data commissioner can prescribe thresholds for registration. And this is what she is going to do through the regulations. But because, as I said, this Act is in force as we speak, the regulations are there, but they're in draft. Strictly speaking, therefore, there is an obligation for all data processors and data controllers to be registered. But of course, you can for the time being say pretty safely, we are waiting for the regulations to be promulgated, which will set out and in fact even give the instruments to confirm this registration, such as the certificates which will be issued. Section 19 to 22, again, which I won't go into details because we'll have another session on Tuesday, as Milia said, where we shall go into the detail of the regulations, discusses this in greater detail. Whereas Section 23 empowers the data commissioner to carry out periodic audits of the processes and systems that controllers and processors are put in place in their organizations. So be aware that the data commissioner can actually turn up and carry out an audit, similar to how other regulators that you may know about do their businesses, just to ensure compliance. So don't be caught flat-footed when that happens. Be aware that it is a possibility. Section 24 of the Act then allows for data processors to appoint, and data processors both and controllers to appoint a data protection officer within their organization, who really is the person who would be in charge within that organization of ensuring adherence to the Act, and is also the person who would be publicly visible, both to members of the public as well as to the data commissioner, to ensure being able to reach to that organization through an organized manner. And for this purpose, whenever an institution decides they want to appoint a data officer, they must publish that within their website and communicate the same to the data commissioner. This person ideally should be well versed in both the matters of law as well as the technical side of things, because they will be the ones guiding the institution in terms of their systems and operations to ensure full compliance from the outset. I will then move briefly to Section 25 of the Act, which really is the cornerstone of the Act because it sets out the principles of data protection. If you count them, there are 8. And if there's one thing that you must know or take away from today's webinar, is what Section 25 provides, right? So just bear with me as I go through them one by one. Number 1 is privacy. always process data with the right of privacy of the data subject in mind. Have that as a default setting. Am I doing right in as far as privacy of the data subject is concerned? Number two, fairness, it's combined. It's fairness, lawfulness, and transparency. So when you're processing data, don't do it under the proverbial cloud of mystery or secrecy. Do it in a transparent manner and in a manner that can be said to be fair and lawful. Number three, purpose. You must restrict yourself when you collect data to the purpose for which it was intended and communicated. So don't change to use data for a reason other than the purpose which you say you are collecting that data for, because then that would be in breach. You collect data for reason X, don't then end up doing Y. Adequacy and relevancy. Data should be limited to only what is adequate and relevant for the purpose for which it was processed. Remember the Huduma number case? The court said, why do you need to go as far as collecting DNA? Why do you need GPS coordinates? All you need is sufficient data to be able to identify whether a person is Kenyan or not. So this was going, I mean, it was a step in being too excessive. Valid explanation. So whenever you're collecting data or processing data that relates to a person's family or their private affairs, you must explain before you collect that data. Why is it required? Right? Accuracy is the other principle. Data must be kept up to date with reasonable steps being taken to ensure that the data is accurate and up to date. There's a famous case which we might discuss in more detail depending on time, of Google Spain case, where the person concerned, after conducting a search on Google, was realizing that Google the searches kept on referring to matters which you can be said to refer to his previous life, which he thought he had walked away from, whereby there was an attempt to attach certain of his assets pursuant to a debt which had accrued. But he had actually sorted out the debt, and he thought that, that now matter is beside me. But several years later, he types on Google, and that's the first thing that springs on the search tab. So he complained to the equivalent of the data commissioner there. And after a lengthy process, both at the commissioner level or the authority there, as well as through the court, he was actually found to be entitled to that right to be forgotten, so to speak, which is a reflection of the need to keep your records or your data up to date and accurate. So have that from an inbuilt point of view or design point of view. You remember what I said in the beginning about retention. Do not keep data for any longer than is necessary. Keep it for just long enough for any required purpose. So many a time people might justify and say, look, I need this data. I might be sued one day, and how will I defend myself if I've given it away or if I've deleted it? So a simple answer is that then don't keep it longer than limitation provides for. So in short, just be aware for what is the outside period of time that I justifiably need to keep this data. And after that, do get rid of it. In terms of transferring data out of Kenya, my colleague Millie will talk about it more, but in short, you must be satisfied that there's proof of adequate safeguards in the jurisdiction where you're transferring that data, or secondly, obtain the consent of the data subject prior to its transfer. So that's a cornerstone. If you get lost, always refer back to section 25, look through it. There are only 8 principles, and just be sure that what you're doing can be married with those principles, and by and large, you should be fine. With that, I will then, and again, yeah, you find that it's married in the EU GDPR. As I said, many legislations, Kenya not being least, has borrowed from the EU GDPR. So if you look at that, you'll see that there's a more or less carrying into Kenya of those principles that are also reflected in the EU GDPR. without further ado, allow me then to hand over to Dan, who will speak on the rights of data subjects.
Thank you, John. So having seen the cornerstone of the Act in Section 25 that sets out the principles and which have been enumerated under the EU GDPR as well, we now come to see how they marry or they are espoused by the rights of the data subject, which in our Act are contained under Section 26. Now, Section 26 sets out 5 rights, which can be divided into 2 parts. The first 3 have an emphasis on consent, and those 3 are the right to be informed of the use to which their personal data is to be put, the right to access their personal data, and the right to object to processing of all or part of their personal data. So that encompasses the aspect of consent, but also transparency in the process. That's why you need to inform them at the time of collection what you are going to apply that data for. The last 2 relate to accuracy of the data, and that is the right to a correction of false or misleading data and the deletion of false or misleading data about them. John has summarized in the Google Spain case, the right to be forgotten, so to speak. Section 26 of our Act is a mirror image of Article 5 of the GDPR, and it's also covered under the UK Data Protection Act. And this provision has come recently into perspective, where a case involving the TVPS production, it's a TV film company, against the commissioner. And what they were doing was they were recording a documentary about mothers experiencing stillbirths. But instead of expressly indicating to the people they were recording that they intended to use that data for purposes of a documentary and explain that aspects of stillbirth to them, what they did is they availed 2 consultation rooms. So they'll record in a maternity consultation room, but then you'll be afforded an opportunity. We'll record. If you prefer recording, you go to one room. If not, you go to the other room. So when an issue arose as to the transparency, especially in terms of explanation of the use of the data, and it was found that the mothers ought to have been informed the full scope of what TVP was, the television production press was doing with that information. So, and also they said that it is important that you are express and clear at inception, and the use of CCTV cameras negated the aspect of clear consent. Now, Section 30 of our Act now sets out the lawful processes, basically how you can process data without the necessity of a consent. And some of them is where it is in the performance of a contract to which the data subject is a party. It is important to emphasize that this contract can only be where that processing is in furtherance of the contract. For example, if I was a model and took a photo with certain details endorsing a brand for billboard purposes, so that is a lawful use. But you cannot take the data for a specific purpose and then apply it and purport to use it on the basis of a contract. And this is a challenge that currently is live. Facebook is facing in the UK. They are facing a dispute that will potentially expose them to liability amongst all data users in Europe. The other one is when you are processing the data for purposes of executing your functions which are of a public nature, or as is usual the case of many exemptions, when you're undertaking a legal obligation, but it has to be a legal obligation that is mandated by written law. The last criteria, which is also of interest and which journalists will often use, is if you're processing the data for scientific research, historical, journalistic, or statistical purposes. In fact, in the case of that I just referred to, the True Vision Productions, it was the first instance where the defense of journalistic purposes was applied. But the court was of the view that the obligation to discharge or to justify the defense is on the data processor or the data controller. And that obligation will therefore be very huge. I will say that the holy grail will always be to process data in upholding section 26. If you put 26 at the back of your banner, then you will be safe for two reasons. The first one is, I've just said you have the obligation to justify reliance on the exception under section 30. But also, as we see in section 32, I'll just press the next slide. Under section 32, a data processor and a data controller bear the burden of proof that consent was consent for a specific purpose had been obtained. Section 34 of the Act restricts the processing of data where it is necessary, especially when its accuracy is being contested by the data subject. And that normally happens, for example, if you're having data that keeps changing, you need to be updating it. I'm just thinking about this and I realized, for example, if you work in an organization where the experience of your staff is always key, and like in a legal law firm, for example, you always say 7 years post-admission experience, or you need date of entry and how long somebody has worked in the firm. It is always important that you keep updating it so that what is displayed is very accurate. Section 39 is on the retention period, which in explanation of the principles my colleague John had expounded on. But what is important is that you only keep the data for as long as it is necessary for the purpose for which it was obtained. The critical thing here is, under the Act, you always realize that when you are given a right to process data or to store anything, it is subjected to the purpose. So that purpose is critical. Then the right to rectification, the right which exposes that right to be forgotten, or also applies, amplifies accuracy provisions under section 40, the right to rectify or erase. So when you have personal data that is now inaccurate or is outdated or it's incomplete or misleading, it's good you rectify that. But when it is now becomes irrelevant or no longer in use, especially for the purpose for which it was obtained, then it needs to be erased or deleted. Just before I move on to the key elements of consent, just to sum up that part of the presentation, there's section 41, which deals on data protection by design or default. I believe my colleague Jacob will expound more on it, but the intention is to amplify on the integrity and confidentiality principle of the data, that you have in place systems and processes that guarantee the security of the data that you have obtained. So in terms of a few, the 4 elements of consent, just for purposes of illustration. The first one is choice, and consent needs to be freely given. The data subject should be given that opportunity to express their choice and control over the use of their data. And this you can achieve by, for example, allowing the data subject to refuse or withdraw consent at any time. And that's why you always see this. Sometimes you receive marketing messages that are indicated to stop SMS this word. So it is very clear. But most importantly, always have an opt-out option that is eminently displayed. Also, just to ensure that that choice is guaranteed, we need to separate consent from other terms or conditions of service so that the consent is clear and it sets out the purpose and is not subject to the provision of service. If you're sending emails, especially the mass emails, it's always good to have prominently displayed an unscribe button, just so that the choice aspect is evident. Then there's the need for specificity of the consent, and that specification relates to both the purpose and the nature of the data that you require. You need to be specific about it. So in this instance, you can always request for consent, like I've said, on separate terms, but also inform the data subject about the nature of the data that's going to be processed and who is going to do it and how they'll be doing it. But also, most importantly, if you're going to transmit it to a third party, then you need to disclose who those third parties are. The consent also has to be expressed. I'll just say, in as much as it could be oral, but it is good to have it in a written statement and very direct and in a simple language. There is no room for implied consent when it comes to consent in terms of data subjects. So when you collect it orally, just have it recorded and stored, but make it very simplified in plain language. The most common one I always see is you tick a box which indicates I agree or I consent. And lastly, there needs to be an affirmative action, some positive conduct of the data subjects that implies that they've agreed to give their consent. Like the example I just given about ticking a box. But most importantly, silence or a pre-tick box does not connote consent. And actually, this has been interpreted by the highest court in Europe, the Court of Justice of European Union, where they delivered a judgment saying that a pre-ticked box indicating allowing them to use your data for purposes of personalized advertisement did not constitute consent. With that, I'll just request my colleague, Miley, to take us to the next part of the act.
Thank you, Dan. So I am going to take you through the topic of sensitive personal data. So what is sensitive personal data? Sensitive personal data is essentially data revealing a person's race, his health status, ethnic social origin, belief, genetic data, biometric data, property details, marital status, family details, sex, or the person's sexual orientation. So generally, the Act prohibits processing of sensitive personal data, except if that processing complies with the principles that Mr. Baluto clearly explained in his presentation. So the Act sets out 5 permitted grounds for processing of sensitive personal data. One of such instances is where a data subject has made that data public. So you can process data if that data, sensitive personal data, if a data subject has made that data public, and also in pursuing a legal claim. If you want to file a suit and you need to use sensitive personal data, that is one of the permitted grounds under the Act. The other ground is where the same is necessary for the performance of a contract. So if a data subject is a party to a contract, and that sensitive personal data is part of the contract, and you need that in order for you to enforce that contract, then that is one of the permitted grounds. The other ground is where it is necessary for protecting the vital interests of a data subject or of another person who's unable to provide consent because they are physically or legally incapable of giving that consent. There's also this aspect of the health status of data subjects. The Act specifically provides that for you to process health data relating to the health of an individual, that needs to be done by or under the responsibility of a healthcare provider or by a person who's subject to the obligation of professional secrecy under the law, for instance, lawyers. So that is what we need to appreciate in relation to sensitive personal data. In addition, the Data Protection Commissioner is allowed to, set out further categories of sensitive personal data and also the permission grounds for processing such sensitive personal data. Moving on swiftly to the concept of transfer of personal data. We've seen a couple of you raising questions on this topic about transfer of personal data outside Kenya. This is quite relevant for multinationals and those who process data in Kenya, but who are not established in Kenya, because the Act itself has an extraterritorial effect. In that sense, that processing transfer of data needs to comply with the provisions under the Act. So the Act sets out 8 conditions that data controllers or data processors need to comply with before they transfer data outside of Kenya. One is that they need to give proof to the data commissioner that they have set up in place appropriate safeguards on the security and protection of the personal data. They also need to confirm that that transfer is necessary for the performance of a contract or implementation of a pre-contractual measure in relation to a data subject's request. The other condition is where it is necessary for the conclusion or performance of a contract. That is one of the conditions where you're allowed to transfer data out of Kenya. The other condition is where the transfer is necessary for any matter of public interest, where you need to pursue a legal claim, obviously, and you need that data transferred. That is one of the conditions. And also where you need to protect the vital interests of a data subject. And lastly, for the purposes of compelling legitimate interest pursued by the data controller or data processor. This concept of compelling legitimate interest has not been subjected to judicial interpretation in Kenya, but we are aware that in jurisdictions such as the European Union, this concept has obtained judicial interpretation to include commercial interest. The Act does provide that the burden of proof is on the data controller or the data processor. So if you're going to transfer data outside of Kenya, and you rely on this ground, then it is for you to prove that that ground that you relied on is a compelling legitimate interest. So essentially, the safeguards that you're required to take or to consider before you transfer data outside of Kenya is that 1, you need to obtain the consent of the data subject, and 2, you need to obtain confirmation on the appropriate safeguards, on the appropriateness of the safeguards that you have. The Act also provides that the Cabinet Secretary can prescribe certain nature of processing that should apply or should be effected through a server or data center located in Kenya. That has not been done yet, but the Act does allow that. So when we reach the question and answer session, we'll go through the practical means of actualizing this in terms of the appropriate safeguards that we need to take, or rather companies need to consider when they're transferring data outside of Kenya. Without further ado, I'll allow my colleague Jacob to take us through the exemptions and jurisprudence in relation to personal data, processing personal data.
All right. Thank you, Millie. Indeed, the Act acknowledges that there are certain instances where it might be impossible to comply with the data protection principles that are espoused in the Act and has been clarified by my colleague John. So there are instances under which the exemption to comply may be obtained. And these are set out in that slide. Basically, if it is a disclosure pursuant to any written law or a court order, then you might be required to disclose without necessarily obtaining consent or complying with other data protection principles. If that information or data is necessary for national security or public interest, or is purely for personal and household activities, then obviously you can process that data without complying with the data protection principles. As my colleague explained, the issue of journalistic, scientific, and other purposes, if you use that information for those purposes, then you may need not to comply with the provisions of the Act. Obviously, the Act allows the Data Commission as well to prescribe other exemptions that might apply that perhaps were not captured within the provision of the Act. Now, in terms of enforcement, so what are the consequences of failing to comply with any provision of the Act, as well as the the data protection principles that are set out in the Act? So anybody who is aggrieved by the data controller or his employer as a result of processing data in accordance with the Act may lodge a complaint with the data commissioner. The complaint may be lodged orally or in writing, and upon lodgement of the complaint, the data commissioner is required to undertake an investigation on that complaint within a period of 90 days. And for purposes of investigating, the data commissioner has the powers to summon, powers to enter certain premises with a court warrant in order to exercise his investigating powers. Obviously, he can order for presentation of documents, production of documents, in order to confirm whether indeed the complaint is justified or not. Upon confirmation, then the data commissioner may issue an enforcement notice to the company or to the entity that is allegedly accused of breaching the provisions of the Act. And the enforcement notice will set out what actions the data controller or the affected party needs to undertake in order to ensure that any breach is rectified or any breach is remedied. And the enforcement notice will also set out the right of the entity to appeal should he be aggrieved by the decision of the data commissioner. Now, in exercise of his investigating powers, if you don't comply with the enforcement notice, that constitutes a criminal offense. And on conviction, the person is liable to a fine not exceeding 5 million Kenya shillings, or imprisonment for a term not more than 2 years, or to both imprisonment and the fine. So as you'll see, the consequences are dire. The fine is quite steep, and therefore it's important for the parties to ensure that they comply with the relevant provisions of data protection. Now, in addition to the powers to investigate and issue enforcement notices, the data commissioner also has powers to issue penalty notices, basically specifying a fine, a penalty, which the alleged person needs to pay in order to compensate, or rather to for the purpose of breach. So the maximum penalty that the data commissioner can issue is 5 million Kenya shillings, or 1% of the turnover of the entity, but up to a maximum of 5 million. So whichever is lower. So as you can see, the penalties are quite stiff, and therefore it is important for parties to comply. Now, in addition to this penalty that the data commissioner can issue, there are other remedies that are available to a person who is aggrieved. So if it's an individual that lodged a complaint, the data commissioner has issued an administrative penalty for failing to comply with the relevant provisions of the Act. If a person fails that as a result of that breach, his rights have been infringed. And when we talk about these rights, basically we are talking about generally to the right of privacy and other rights as espoused in the Bill of Rights under the Constitution. So if as a result of breach of the Data Protection Act, a person is aggrieved and feels that either he's distressed or his family has been, family privacy has been, exposed and so on and so forth, then he can approach courts and, ask for compensation as a result of that. And this can be financial or otherwise. In addition to the other remedies, the data commissioner has is a preservation order in the event that the data commissioner feels that there's some information which might be destroyed and therefore evidence is lost, then he can apply to court for purposes of preserving that evidence for purposes of prosecution of offenses under the Act. Now, in addition to the administrative and contractual remedies that are available, there are other remedies or other offenses that are set out in the Act. So as you can see, the Act prescribes both civil penalties as well as criminal penalties for failure to observe or rather to comply with the provisions of the Act. And these are under Section 72 of the Act, and basically the offense is unlawful disclosure of personal data. So if a data controller or a data processor fails, or rather unlawfully discloses a personal data belonging to a person, that constitutes an offense, and they can be liable for that. And the general penalties for which no penalties are prescribed under the Act, the penalty is a fine of up to 3 million Kenya shillings, or imprisonment for a term not exceeding 10 years. So these are criminal penalties that are in addition to the administrative penalties that I've alluded to before. The other thing is the delegation, the powers of the cabinet secretary. Obviously, this is just a skeleton act that sets out the principles, but obviously they require regulations in order to implement certain provisions of this act. And therefore, the cabinet secretary in charge of ICT has the powers to make regulations for purposes of ensuring that certain provisions of this act are implemented. In addition to the power of the cabinet secretary, the data commissioner also has powers to issue guidelines, issue codes of practice to aid and to guide the data controllers, processors, and data protection officers in implementing certain provisions of this act. Pursuant to this, the data commissioner has issued 2 guidelines. That is the guidance note on consent, as well as a guidance note on data protection impact assessment. These are some of the guidelines that have been issued in order to help implement the provisions of the Act. Obviously, we are expecting that the regulations which have been published and which have gone through stakeholder meetings and consultations, once published, will bring into effect the other salient provisions of the Act, including the requirements for registration. So let's look out for that. And at our training, we'll be able to discuss some of the provisions of those draft regulations as we await their implementation. So having said that, then what next? Yes, we've seen that actually the Data Protection Act sets out certain principles that we need to comply with, failure to which there are penalties, both administrative as well as criminal sanctions for failure to comply. Then what do we need to do as potential data processors or potential data controllers in the room? There are a few tips that we'll set out that perhaps you might consider in the long term, in the short term as well as long term, as we look to the regulations being implemented, which we believe should be sooner, since the stakeholder consultation process has been done. The first thing that we would recommend for parties to consider is undertaking a systems audit to identify what personal data are within your systems or are housed or are contained in our organization. This could be employee data, this could be customer data, this could be perhaps data sitting in either your systems or physically in your offices. Some data might have actually and might actually not be necessary, and therefore there will be need to rather erase or delete or destroy them. So you need to undertake that review and audit in order to ensure that you're complying with the Data Protection Act. Obviously, some of the principles we discuss about data minimization as well as the period within which you need to put that information. So we need to do that audit in order to identify whether the information existing in our system, we really need them. And if we don't, then we can be able to dispatch them from our systems. Perhaps bankers in the room, if you have still the facility was repaid 20, 30 years ago, but you still retain the ID cards of the employees and of the customers and so on and so forth, that information might not be necessary, and therefore you might need to dispose it off in keeping with the principles set out in Section 25 of the Act. So the other thing that you need to do is to develop a data protection policy. A data protection policy, basically, an equivalent to a human resource handbook that sets out what are the rights of the data, what are the principles of the data protection, so that the employees are aware of who is responsible for keeping that data, under what circumstances the data can be disclosed, and why is that data being kept, and so on and so forth. So this is a very useful policy that employers need to consider, so that that data that data, or rather the employees are explained to the reason why their data is being kept, and the reasons, and rather the lawful reasons for keeping that data, as well as under what circumstances that data is going to be disclosed. So it's important to develop this policy. So this is an in-looking policy, especially with regard to employees. The other policy is a privacy policy, which is an outside-looking policy, especially with regard to your customers as well as clients. Some of these are embedded already in your documents for bankers in the room. These are in your T's and part of your T's, T and C's. But and online companies, you need to consider, in addition to your terms and conditions, setting out a separate private policy that details how you collect data, how that data is processed, and the rights of the data subject in relation to handling of that data. So that's very important to come up with that policy as well. And as my colleague said, in addition to that terms and conditions, whenever you accept it, then accepting that TS and condition in itself without necessarily having a separate privacy policy where the customers accept might not be sufficient for purposes of obtaining consent. So you need to ensure that you side by side by your T&Cs, you also have your privacy policy. The other thing that you might consider, and my colleague has talked about, is appointment of data protection officer, who is basically the person concerned with ensuring that the company complies with the data protection. Because if you don't assign a specific person with this responsibility, many things may fall through the cracks. So it's very important to designate either an existing employee with the necessary skills and competence to be able to help the company comply with obligations and report whenever there's any data breach. So it's a very important function to have in your company. The other thing is registration of data commissioner. Obviously, we are hoping that with the coming into force of the regulations, it will be able to guide companies as to whether they need to register or not. As the draft exists, there are certain companies that don't need to register if they meet a certain threshold. If you are below that threshold, then you might not be able to register. But I will wait until we see the published regulations in order to identify whether registration is necessary or required. As per the draft regulations, if you have a turnover of less than 5 million Kenya shillings and less than 10 employees, you might not be required to register. However, there are certain critical sectors of the economy, and those operating in that industry may be required to register, notwithstanding that they don't meet the threshold. But that will be subject to our discussion next week on 27. The other critical thing that you need to consider is to establish suitable organizational as well as technical measures to prevent any potential breaches or unauthorized access or illegal access to personal data. Now, this is a requirement under the Act, Section 41. It requires you to put in place measures either by design or by default to ensure that any data you process going forward complies with the provisions of the Act, and in particular, the principles set out in Section 25. Now, the Act does not give specific details to the organization and technical measures, but organizational measures might include, appointing a data protection, officer, coming up with a data protection policy, privacy policy. So those are organizational measures, things that you do as an organization in order to ensure that you comply with the Act. Now, in terms of technical, these are more technical, the more IT and systems measures and security measures you need to inbuild into your system to ensure that data that you have collected that qualify as personal data is not authorized, is not disclosed to any unauthorized person, and is kept in confidentially within the company, either through your IT systems or physically in the office. And therefore, only those who are authorized to access that data has those data. So you are required to put in those measures in place. And there's no one-fit-all measures that you can put. It depends with the size of the organization and the amount of personal data that you actually process. And as you said before, processing has a life cycle, and it starts from the time you collect the information, you store the information, and ends with the eraser or destruction of that information. So you need to have measures that ensure that throughout that cycle, that information is safeguarded and the integrity of that information is safeguarded. So you need to ensure that you do that. Now, data protection by design basically means that before you implement any system, you launch any product, you need, as part of your risk profile, design and have in place measures to ensure if that service that you want to launch, if that product that you want to launch, if that system that you want to install, if that activity that you undertake as an organization, is it likely to affect personal data? Is personal data likely to be involved in that, in that exercise? So you need to come up with measures to ensure that before you launch that product, at the inception stage of any product, of any design, or any service, or any activity, you come up with measures to ensure that if that activity will involve personal data, you can have mitigation measures, risk assessment of the data that's likely to be involved, and how you are going to mitigate any risk associated with that data. The other thing is data protection by default. Now, what this means is that upon implementation of that service, that product, or that system, when at the time of collection of that data, you need to have measures in place to ensure that at the time of processing, you have safeguards to ensure that the integrity of that information, the confidentiality of that information is protected. So data by default means the measures you put in place at the time of collection of that information, storage of that information, and the destruction of that information. So you need to have both measures. And something that will guide you in coming up with these measures is actually a data protection impact assessment. Although this is not a mandatory exercise, or rather audit to undertake, or assessment to undertake, you are required to undertake it if the systems or the operations you are likely to undertake is likely to involve high risk to the personal data of the people involved. So you are supposed to undertake that. Other than that, you are not. It's not mandatory to undertake, but it's advisable to do so, especially at this stage when you are assessing your systems to understand what kind of data you have. It's important to do it for purposes of identifying the actual data that you have, how that data is stored or is processed, and whether you have sufficient measures in place to ensure that those gaps are sealed. So it is important to consider undertaking this at this stage. The other thing, and just to say in relation to the data protection impact assessment, actually the commissioner has come up with a guidance note to guide the parties in deciding whether or not to undertake a data protection impact assessment. So we invite you to just go through to identify under what circumstances the data commissioner recommends that a company undertakes a data protection impact assessment. In relation to the other things that you might consider doing, there could be instances where your data is sitting with third parties who are who are not within your control. For instance, your employee data is being hosted by either cloud or by a third party in their systems, and you need to ensure that you identify these third parties who are holding your information, just to ensure that they have adequate measures to ensure that the information that they are holding on your behalf are safeguarded, and that they have in place measures to ensure that that information is not disclosed. Because as the primary owner of that data, you are under an obligation to ensure that any data that you process and you disclose to third parties are protected and safeguarded. So it is important to evaluate which third parties are holding your data for purposes of determining and ensuring that they put in place adequate measures to ensure that that information that they hold in your behalf is safeguarded. So there are some of the things that we believe that you can consider for purposes of implementing the provisions of the Act, more so in light of the fact that there are stiff penalties should you be found to be in breach of any principles or any provisions of the Act. With that, I would hand it back to John, just to take us a little bit of some jurisprudence in this area, and thereafter we'll open it up to questions and answers.
Okay, yeah, thanks, Jacob. I'll run very swiftly because of time through the jurisprudence. The thing, as we've indicated, is that this act came into force rather recently, so Kenyan jurisprudence is still rather sparse. And for that reason, we need to look outside and see what are other courts out there doing, and as far as data protection is concerned. So let's start with the Supreme Court case of England, Morrison's versus several claimants. So in this case, what happened is that Morrison's, for those of you who might not know, is actually a supermarket chain in the UK. And within that supermarket was a disgruntled employee, for lack of a better word, who had an axe to grind against his employers. So this was a person who had access to a host of data related to his fellow employees. So typically anyone here who might sit in HR or in accounts, you would, by virtue of your position in that company, have this information. What does this employee do? He gets that data, walks out, and goes to sell it, literally, to third parties for the purpose of them to publish it out there. Put it either on the internet or website, just make it public. That's what he wanted to disclose this information in obvious breach of the UK Data Protection Act. For good conscience, these third parties who had been given this information decided, no, we're not going to do what this employee wants us to do. We will instead whistleblow on him. So they turned back to the employer and told the employer, this is what your employee is doing. Can you look into it? But in the course of that, the employees got to know that, hang on, our data has actually been breached. So what do? They turned around and sued Morrison. Now, the issue was whether an employer can be found vicariously liable for acts of an employee under the DPA, right? And vicarious liability in essence means you are still being found liable, even though you yourself didn't do the act complained of, you're being found liable by virtue of your relationship or by virtue of your position. So it's an imposition of liability under the law. The High Court and the Court of Appeal found that Morrisons are actually vicariously liable for the acts of their former employee under the DPA. The matter went all the way to the Supreme Court, and the Supreme Court departed from what the High Court and the Court of Appeal had found, but not on the issue of whether an employer can be found vicariously liable or not. What they departed was on the proper test to find whether or not the employer should be vicariously liable. So what they found is that this employee had gone on the so-called frolic of his own. They applied something that is called the cross connection test and found that Morrisons would not be found liable. So whereas Morrisons briefed a self-relief, the principle that an employer, and this is what the take-home for all employers, can still be found vicariously liable for acts of their employees in breach of the DPA still holds. So in other words, if you're a data controller and a data processor violates or breaches the DPA, you would be found liable. So bear that in mind. The other case, perhaps time allowing, is Duchess versus, although I see we're really, maybe I can quickly run through this and I'll skip the last one. So this involved an interesting case where the Duchess of Sussex, you might know as Meghan Markle, sued a newspaper that is known as the Mail on Sunday, which had published a series of letters that was exchanged between the princess and her father. And it was found that this had actually was in breach of her right to privacy or DPA. So whereas the case was still ongoing as some time back, the key takeaway here is the plea or the defense that was being raised by the defendant. Remember that one of the exemptions under processing of data is if it is in connection with a journalistic endeavor. So these are journalists. The Mail on Sundays are the journalists. So similar to our provision here, there's an exemption for DPA when it comes to journalism. And what we await to see is how will the court resolve this issue of exemption pursuant to journalistic endeavors. There's also the key thing to be taken away from this court. There was a preliminary issue where the court ruled that it does not matter what is going on in the mind of the person who commits the data breach, so that you're not going to look into the motive or the intent. It is strict liability. If the data breach happens, it has happened, and now it's whether or not there's a lawful excuse for the breach. So bear that in mind. The law will not look at your motive, your intention. If you breach, it will not look at that. It will just say, look, there has been a breach. Is there a justifiable excuse for that breach? So because of time, I'd have also gone through the case of Google Spain, but I alluded to it earlier. That case merely concerned the right to be forgotten, where an individual, despite having resolved the issue, which kept on coming up on Google, was being reminded about matters which he wanted to forget. So that is the right to be forgotten, or the obligation on a data controller to keep his or her records up to date with developments in life. And on that note, I would then allow for the question and answer session, just running down through the questions one by one, which you have kindly shared with us. Time allowing, we have around 15 minutes left for that. So the first question is, please share some practical ways to address the restrictions on transfer of personal data outside Kenya, and that I'll ask Emily to answer, since that was part of our discussion.
One of the practical ways you can do this, one of them is first to ensure that you obtain consent. You remember, before you transfer data, the two conditions, the two safeguards rather that the Act stipulates are that one, you need to obtain consent, and you need to put in appropriate safeguards. So for consent, my colleague Dan discussed this in greater detail, that consent needs to be manifest, expressed, informed. So you comply with that first. And then in terms of appropriate safeguards, I will propose having some sort of a data transfer agreement with the entity that you're transferring the data to. And also it will be helpful if the entity that you're transferring the data to is based in a jurisdiction that has data protection laws. As you will have noticed, one of the conditions under the Act is that you have to prove to the Data Protection Commissioner is that the other entity has put in place appropriate safeguards and is in a jurisdiction which has laws which are commensurate to those of Kenya. So that is the example. That is one of the practical examples that I will give in relation to transfer of data, personal data outside Kenya.
Yeah. The other thing you may consider doing is to do a DPIA, the Data Protection Impact Assessment, just to assess what are the potential risks that are associated with the transfer of that data. If you perhaps you are transferring that data to a jurisdiction which has no, which has no data protection law, then you might need to come up with a certain minimum, safeguards to ensure that that company or that jurisdiction establishes certain minimum measures to ensure that that information is not going to be disclosed once you transfer it outside Kenya. So that's something that you might also consider, undertaking, and that will go a long way in satisfying the data commissioner that actually in your organization you have sufficient safeguards, but the person receiving that information has also put in place sufficient safeguards to ensure that that data is not going to be disclosed unlawfully.
Thanks for that. Then the next question is, are there any restrictions on Kenyan entities or persons accessing personal data stored outside Kenya? And for that, again, that relates to, well, it's not really transfer from Kenya outside, but it's other outside coming in. So on that, and I'll allow any of my colleagues to just comment in addition to what I say. I wouldn't put it as a restriction. What I would caution you is to be aware when you are dealing with data from outside Kenya, what is the regime of law that you are applying yourself or putting yourself or subjecting yourself to. So if you're now dealing with European data, then you should be aware that you're falling squarely within EU GDPR. So be aware of what are the, what then are you required based on that jurisdiction. So that's what I would say. There's no restriction. There is a requirement to be aware if you go outside Kenya and deal with Kenya relating to a foreign jurisdiction, what do you fall under? And most prevalent or most extensive, obviously, is the EU jurisdiction.
Yeah, interestingly, if you look at the application section 4 of the Act, it seems to apply to entities established or resident in Kenya and processing personal data while in Kenya. So if that entity is in Kenya and is processing data in Kenya, although that personal data might not be of of a person resident in Kenya or not, then arguably you might fall within the ambit of the act. So as John says, the best case scenario, ensure that you have measures in place to ensure that at the minimum you comply with the provisions of the act, so that you are not open to any claims from any third party.
So there's a comment from Lavin. She says, amazing presentation. Can we have the slides after the webinar? I will leave that to the business development team to look into the contacts who have joined us today and share the slides where possible. I have a brief question. Where do we get the balance between the right? This story is from Linus Melly. Where do we get the balance between the right of access to services and data rights under Section 26? For instance, I have a right to object to data processing, but the service provider will deny me services whenever I object to the request to process my data. Best example is when WhatsApp forced its members to agree to data sharing between WhatsApp and Facebook, failure to which WhatsApp services were then denied. So this one is for you, Dan.
I think the issue is about, and that's what I was saying, you look at it in the context of what is required if you're a data controller or a data subject. That is, what is required of you to fulfill the rights of the subjects in terms of sharing of consent. The best case scenario is to ensure that your consent is separate from the services being provided. And that is the best case scenario that will protect. The only thing is that if you are in a position where you need a service and it is tied down to consent for the data, then at that point you make you could call it a commercial decision per se. But from a data controller, data processor perspective, it is better to err on the side to caution on the side of upholding the rights of the subject, and which is ensure that that consent is separate. And that's why when my colleague Jacob was talking about what next for entities, he was mentioning that you don't include the consent in the terms and conditions, but have a separate privacy policy where somebody then consents to that data.
Yeah. If you look at it strictly speaking, it appears that the requirement to access, the requirement for you to consent to the processing of your data before you access service would not actually comply with the requirement to give a free consent, because that free consent would be deemed to be not freely given because it's a conditional. And therefore, that's something that perhaps can be challenged on the basis that I gave consent because I wanted to use the service, not because I understood the nature of the processing and so on and so forth. So I think that's something that can be challenged on the basis that you are denying me service purely because.
In fact, the case law from Europe, which we keep going to because our act borrows, that have found that undue influence, any amount of undue influence, including the undue influence being as a bait to a service, invalidates the consent.
All right, thanks for that. So the next question is, please comment on employers who publish press notices to the effect that this employee is no longer with us. Isn't this against the privacy of the employee? So this perhaps they could.
Yes, arguably, but so the question here, and I think my colleagues mentioned, is about legitimate interest of the employees. So you are weighing the right of non-disclosure, or rather protection of privacy, against the legitimate interest. And as Millie said, it's something that you need to check whether the legitimate interest, or rather the interest you are trying to protect by publishing that information, outweighs the right of privacy. And I can say it's circumstantial because it depends on the circumstances. If perhaps you've discovered that that person is still, entering into contracts or still pursuing your clients, or or doing something that you are seeking to protect, and you have used all means to ensure that he stops that and is not doing, then you can argue that your legitimate interest that you are trying to protect by publishing that notice outweighs the right of privacy. Then in that circumstances, you might be justified to publish that information, but something that you need to look from case to case and identify what legitimate interest you are seeking to protect.
Yeah, that would also be in consonance with Section 25, which one of the principles, remember, is you can publish provided you're doing it in a fair, lawful, and transparent manner. So are you being fair when you're publishing this notice? Of course, you're being fair because you're trying to safeguard the public at large, not to transact with this person because it's no longer an employee. Is it being lawful? Yes, it is in furtherance of a legitimate interest. And also you're being transparent about it because you're actually putting it out there for also that employee to see in the event there's any objection. Perhaps what you should do is don't put any more information than is necessary. Yeah. So don't put why it is the person no longer is with you. Just say person is no longer with you as of this day. That should be sufficient. In each of the conditions or grounds for transfer of data outside Kenya under section 48A, B, and C must all be satisfied, or are they in the alternative? So that was Millie.
Yes, the first A, B, and C. So section 48 sets out the conditions for a transfer of data outside Kenya. So the first three must be satisfied. The first one being that you have to give proof to the data commissioner that you have set up appropriate safeguards with respect to the security and protection of the personal data, and that where you're transferring that data to, the entity that you're transferring that data to also has set up appropriate safeguards with respect to the security and protection of personal data, and that they are appropriate safeguards, including in terms of jurisdictions where they have data protection laws that are commensurate to the Kenyan data protection laws. And also the third one that I think this is where the contention is, the where the transfer is necessary. So that's where there's the option. So you need to confirm or rather prove that the transfer is necessary for one, for the performance, either for the performance of a contract, for the conclusion of a contract, or if it is for a matter of public interest, or if it is for pursuing a legal claim, or if it is in relation to the protection of the vital interest of a data subject, and finally, for the purpose of a compelling legitimate interest pursued by a data controller or a data processor. That's where the alternative falls. But for the rest, those must be satisfied.
Yeah, yeah, that's true, because A and B talks about security in the sense of putting in place measures, and C talks about the justification. So you must have justification for the transfer. And if you have the justification, you need to put in place measures to ensure that that personal data is safeguarded upon transfer.
Then the next question is, what is the limit on property owners when they put up CCTV public notices outside buildings? Is this enough to say a notice was put up? So on that one, let me comment. I think first start with legitimate. What's your interest when you're putting up this CCTV? Obviously, it's security. So what then should guide you? The principles, adequacy. The CCTV, is it pointing beyond where it should be pointing to secure your building, or is it pointing to your neighbor's house? And therefore you can see what your neighbor is doing. Obviously, if it's excessive, that will fall afoul. Secondly, how long are you keeping the CCTV for? There should be a retention policy that doesn't allow you to keep CCTV beyond for any period that is necessary. Indeed, under the one of the European nations, there's actually a case where they found that they were internally within the office, they were keeping CCTV for a period which really, when they were put to task, and that's why you're keeping CCTV for 6 months, I believe it was also. And they couldn't justify why they required it for that long. So again, remember, you need to marry whatever legitimate interest you have to the principles set out under section 25, in which case is how long is the retention policy. And also, as you set up this CCTV, make sure they're not unnecessarily intrusive, and they only point to where is necessary for safeguarding or securing the premises. So in exercising its prosecutorial powers, how strong is the Commission's quasi-judicial power in ensuring compliance with its decisions or fines? So Jacob, you spoke on the...
Yeah, the DPA, the data commissioner, does not have prosecutorial powers. He only has the investigative powers, and therefore, although he can levy administrative fines, which he doesn't need to go to court, should he, wish to pursue a criminal case, then obviously the other organs of government comes in, and therefore the DCI and the prosecutor would be involved for that purpose. He doesn't have the prosecutorial powers.
Thanks.
So he'll have to rely on the other organs of the government.
Thanks. The next question comes from Alan Meso. He asks two questions. Number one, under section 74 of the Act, the data commissioner may develop sector-specific guidelines. Are there any plans to develop guidelines for law firms? If not, is this something you would wish to pursue with the data commissioner in collaboration with the LSK?
Yeah. At the moment, as my colleague alluded to, the data commissioner was just appointed, I think, towards the end of last year. She has actually established a number of guidelines on consent, on DPIA, as well as the regulations that are coming up, and I think a lot of activities happening. Sector specific, depending with the amount of data we process and so on and so forth, you may consider doing so, but at the moment she hasn't. But this is something that we can perhaps pursue and see whether we can champion this and work with the data commission to come up with certain regulations that should be able to guide the lawyers in processing personal data, because obviously as lawyers we process a lot of data for our clients.
And the second question from Alan is that, does the certification by third parties referred to under section 74 of the Act provide room for certification experts? If yes, are there any draft regulations in this regard? So this is section 74 of the Act, the certification of third party 74(1)(c).
No, rather guidelines have been issued yet in this regard, but we hope that as we roll out the regulations as they come into force, there'll be further guidance on this matter, and the data commissioner may be able to issue regulations in this regard. So there's no really guidance at the moment in this in Kenya.
Thanks. Then, is the person to whom data is transferred, i.e. the recipient, outside Kenya? So you're in Kenya and you transfer to Uganda, for instance, considered to be a data controller or data processor, or both, for purposes of the Act? So the recipient of this information.
The Act does not go into the description of the person receiving the data, but whether that person is a data controller or a data processor depends on what they actually do. Because as Mr. Baluto eloquently described during his presentation, he explained what a data controller does and what a data processor does. So in terms of if you're making a decision in relation to processing of data, you're a data controller. But if you're the person who's actually undertaking the processing of data, then you will be described as the data processor. So it all depends. You can ever also be both. You can also be the person determining how that data is going to be processed, and you could be the same person who actually processes that data.
Thanks for that. Isabella Nyambura asks, is it lawful for an employer to obtain staff medical reports from medical providers without the knowledge of the employee in case the employer is paying medical insurance cover? Well, I mean, on that, I would say the answer there seems to be a sort of overwhelming no. It is not, I mean, in fact, medical data or health data is actually what is under the Act sensitive personal data. So the threshold you need to satisfy to justify your dealing with that data is even higher than personal data. So for you to proceed to obtain these records in the absence of consent from the employee would fall afoul of the provisions of the Act. And it doesn't matter whether, I mean, the fact that you are paying the medical cover for the employee does then not take away the right to privacy under the Act. Sorry, we seem to have exceeded our time, but we'll push on for a few more minutes. I know 4 o'clock is approaching the rush hour. Can a data subject be a deceased person? Okay, that's a good one. For example, if the body of a deceased person is photographed and circulated on social media, will this deceased person be treated as a data subject? So the act is not, it's silent. I'll say it's silent on whether or not the description of a data subject includes a disease. But this is what I'll say on this. On the side of caution. If you have data, it will invariably arise that from time to time, because death is inevitable, one time you'll be dealing with data of a deceased person. Does that then authorize you to throw out the Data Protection Act and say it is no longer applicable because the person has died? Therefore, I can disseminate this information as I please. To my mind, that will be a resounding no. The person can be represented through his or her legal representative. That person, called the legal representative, can issue the consents where necessary, so that it will not be an answer to you to say, look, if the person is deceased, where do I get the consent that I need? Who do I consult? So the way to go about it is to err on the side of caution, respect the rights of the person who, as I said, you might have data which at one point or other, because of the state of life, will become data pertaining to a deceased person, which then does not relieve a data processor or controller of the obligations under the Act. Okay. Does the DPO have to be located in Kenya, or can he or she be in another country in the event the controller is part of a multinational group? So first of all, the thing you need to realize under the Act is that appointment of a DPO is not obligatory. So the moment you're appointing a DPO, it is something that you're doing just in furtherance of your own wish to adhere to the Act. My view of it is that there is no express bar in terms of nationality as to the data protection officer. So if you do have a multinational that operations cut across borders, provided that officer meets the requirements which say the person needs to have the technical competence, and also the person needs to be aware of the legal provisions that subsist in Kenya, then I do not see that there'd be any bar for their appointment as an officer to cut across various multinational groups, provided that you also go ahead and then inform the data commissioner so that the data commissioner is aware of that person's contact details, and you also publish it on your website. Again, about the slides, we shall look at the contacts details, and I'll defer to the people in our BD department to reach out to you. Alan Meso, I believe that's the same question that has been answered. And given the fact that the processing of data in connection with children is a more sensitive matter, have any of you come across a more reliable way of ascertaining the age of a visitor to an online site whose products are restricted to adults, say sellers of alcohol, for instance? That is different from the current practice of asking the visitor to indicate that they are over 18, which obviously cannot be independently verified. And that is from Laura Kenyan. So I think on consent it was that.
This is one of the things we've been grappling with about ascertaining the age of minors and how to go about it. We've seen what mostly the alcoholic beverage entities do in terms of just an opt-in procedure. You decide by yourself, but the act seems to be cognizant of that difficulty and makes it subject to certain criteria such as available technology or the nature of the data, proportion of such data likely to be that of a child. So this will be subject to technology. There is no, from the act or from our current interaction, there is no specific way that we've established to ascertaining the age, or especially for online services. But as technology evolves, we wait to see what people will come up with.
Yeah, well, what you need to remember at the back of your mind that it's your obligation to confirm whether or not the consent was obtained. So the threshold is quite high, and we are. I don't think we are aware at the moment whether there's any technology that will help you to do that. But we believe that this is something that will develop with time to be able to come up with measures that can help you ascertain that. But something that we really grapple with.
Yeah, that's a good question. I think obviously there's a balance to be struck between, putting in systems that can even prohibit or make a system less, easy to use for your users. So that's a balance you need to strike between things like putting in age checking mechanisms, as well as ease of use. Because if you now start telling someone, okay, confirm you're over 18, submit documents in PDF version, then I mean it can be quite a difficult task to do. I think what you do is show that you've done what you can do. You've asked for the person to verify their age. That person has clicked and said they're over 18. It then cannot be the very same person turning around to say you've breached my rights by processing my data. Yet it's the same person who says they're over 18. So a lot of these things is an evolving field. We shall look around if there are any decisions coming emanating from the various jurisdiction of that question, which is quite insightful. Thank you. And we shall update or issue an alert as and when possible. So with that, I think we then come to the end of our presentation for today. Remember, there is a further session we'll have on Tuesday, same time, 2:30 to 4, when we shall tackle the draft regulations in detail, and possibly have a guest speaker from the Office of the Data Commissioner join us on that day, which we shall confirm in advance of that date. So thank you all very much for joining us today, and we wish you a pleasant rest of the day and afternoon. Thank you.